Assalamualaikum and a very good morning. Here, my group members will be talking a little on the breakdown of marriage regarding behavior. So let's start with it. The LRA 1976 recognizes the breakdown of marriage as the sole ground for divorce. Thus, the law only requires one of the parties of the marriage to petition for divorce, and in general, after a petition is made, the court has a duty to inquire the facts which caused the breakdown of the marriage, and if the court is satisfied, it will then make a decree for the dissolution of marriage. And the sections in the LRA relating to it are Section 53, which is the breakdown of marriage to be the sole ground for divorce, and Section 54 on the proof of breakdown. Okay, marriage, also called as matrimony or wedlock, is the intimate, recognized union between a man and a woman that establishes rights and obligations between them as well as their children and their in-laws. As for dissolution of marriage is also just another term of saying divorce, and it refers to the process by which a couple can end their marriage permanently. The spouse filing to end the marriage is based on the claim that the other was engaged in a specific type of misconduct which leads to the breakup. Grounds for fault varies, but most common are adultery, behavior, desertion, and living apart. Divorce is under Part 6 of the Law Reform Act 1976. The court has the power to grant decree of divorce, which is stated under Section 48, which is the extent of power to grant relief. Next, unreasonable behavior. Unreasonable behavior is the most common reason of breakdown of a marriage, as it enables a quick divorce as opposed to the other three reasons, which require separation of at least 2 years, and it doesn't require any of the parties to commit adultery. Unreasonable behavior is the term used to describe the fact that a person has behaved in such a way that their partner or spouse cannot reasonably be expected to live with them anymore. And under the LRA in 1976, the petitioner has to prove that the respondent has behaved in a particular way which the petitioner cannot reasonably be expected to live with the respondent. Behavior that cannot reasonably be expected to live satisfies the requirement of Section 54(1)(b).
I'm going to present on the types of unreasonable behavior and some cases to illustrate situation of unreasonable behavior that leads to breakdown of marriage. The most common examples of unreasonable behavior are domestic abuse, secondly, excessive or lack of sex, third, inappropriate association or relationship with other persons, fourth, verbal abuse, fifth, social isolation, last but not least, drunkenness. In this case, Jayakumar anak lelaki Govindasamy and Amota anak perempuan N.K. Ratnam. According to the husbands, the marriage began to show signs of strain sometimes in late 2003, and wife began to behave unreasonably. It started with suspicion and accusation by the wife of affairs with colleagues or any lady friends of the husband's. And even though husband maintained that he has informed his wife of his whereabouts, the wife refused to believe and made accusations that husband was visiting prostitutes and infecting her with sexual diseases which led her to have miscarriages. The accusations were spread to friends and families of both sides. Abusive attitude continued, with the wife openly declaring the calls made to the house by female callers as being made by prostitutes. The husband took it in his stride, even though during that time he was diagnosed with a serious type 2 diabetes. The breaking point of the marriage was a series of events that happened between 2003 and 2004. The husband heard the wife had accused him of touching the eldest daughter's breast and buttocks intimately. The turning point further comes, which it was the day when the husband has just finished his final examinations, and though he insisted he had informed the wife of his intention to spend the day in Pahang. Instead of trusting him, the wife left messages on the husband's phone, behaved erratically, and threatened to call the police about his disappearance. She even screamed loudly and made a scene at the gate of the house the day after husband comes home. Fed up and reaching his breaking point, the husband slept in the room, separate bedroom scene that night, and moved out from the house in March 2004. From the husband's evidence and the affidavit in answer to the petition by wife, the court is satisfied that the marriage has irretrievably brought down due to the unreasonable behavior of the wife. Indeed, the husband has also managed to convince this court that he had lived apart from his wife for a period of 5 years immediately preceding the presentation of the petition, a requirement of proof of breakdown of marriage under Section 54 Clause 1 Subclause D of the LRA 1976. Besides that, the wife had not managed to rebuke that the marriage had irretrievably broken down. In fact, her behavior in not attending court had reinforced the husband's assertion that she is impossible to live with. The marriage is not resolved, will remain as just an empty shell.
So moving on, we are going into the views on dissolution of behavior, where there are two types of view, where the first view is about the nature of the behavior and the second view is about determining that the petitioner can or cannot live with the respondent. In the first view, the petitioner cannot live with him anymore. So this view was derived from the case of Katz and Turler, where the both respondents in these cases were having a disease that changed their behavior or nature of behavior. Therefore, the court gave a grant for their divorce, because even though the behavior was not in their state of mind, but the court still consider the act of their behavior is a nature of themselves. So in the second view, it is about the determining whether petitioner can live or cannot. The court need to take consideration on the part of character, personality, disposition, and the behavior of both parties, where these are going to determine it in the A, reasonableness test, B, behavior test, and C, breach of the obligation between parties. And the first one is the reasonableness test. It was defined as would any right person come into a conclusion when the husband has acted in a way that the wife cannot be expected to live with him anymore. So the court must take consideration in three things, where the first one is about what the husband did, the second one what the effect on the petitioner, and the third one is in the light of that whether the wife still can live with him or not. So in the behavior test, the court need to take test on both parties' behavior. So in the third one is where is about the breach of the obligation between both parties. It was derived from the case of peasant and peasant, where the husband alleged that the wife is not giving him any his nature demands. So the court held that the wife behavior, such of not giving him any his natural effect demand is not considered as a breach obligation to the marriage. So therefore the divorce was dismissed.
Assalamualaikum Madam, my name is Saifa Azri binti Azman, and today I will be presenting about the possibilities of raising grounds of behavior for divorce. First and foremost, there is a high possibility that either one of the party may make a petition for divorce on the grounds of behavior. In order to make it possible, the petitioner must prove or fulfill all of the elements of the unreasonable behavior on part of the respondent. Next, the petitioner must also prove the unreasonable behavior, where it can be in many ways. For instance, if the respondent is a cruel person by always abusing the petitioner, thus it is considered as a serious condition, and this is actually a major problem. However, if the respondent is just an irresponsible person by not taking care of his family, or maybe he's too busy for his work and doesn't have any time to be spent with his family, thus this is considered as a normal condition, and this is just a minor problem. Furthermore, the behavior of the respondent must also be in his natural conduct. For example, in the beginning of the marriage, the respondent is actually a very kind and a gentleman person, but due to the constant quarrel between him and his wife because of the presence of the third party, thus he accidentally hit his wife's face. This kind of action is actually not considered as his own natural behavior. And why is that so? It is because his own action at that moment was actually influenced by an outside element. Lastly, the petitioner must also prove that she or he cannot reasonably live with the respondent, and this can be referred to the case of Savinder Kaur and Dharma Singh. Next, I will jump into conclusion for the breakdown of marriage on the grounds of behavior. Under the law of UK, we must refer to the Matrimonial Clauses Act, while under Malaysian law, we must refer to Law Reform Marriage and Divorce Act 1976. For the breakdown of marriage on the grounds of behavior in Malaysia, the most important element is that the petitioner has to prove that the respondent has behaved in a particular way where the petitioner cannot reasonably be expected to live with the respondent.